afternoon, everyone.
Good afternoon.
Good afternoon.
Assalamualaikum. Good afternoon, sir. We will start the event just after 5 minutes.
Okay, fine. Thank you so much. Thank you so
Thank
much.
you, sir. Thank you, sir. Assalamu alaikum and a very good afternoon to you all. Welcome to the fourth session of the preliminary round of the BIAC International Inter-University Arbitration Contest 2023 organized by Bangladesh International Arbitration Center BIAC and supported by BRAC Bank PLC, Mutual Trust Bank and IFIC Bank. I'm Mumina Haq, Assistant Counsel of BIAC, and I have the honor to facilitate this session. Bangladesh International Arbitration Center began its journey back in April 2011 as the first institution for alternative dispute resolution in the country, under a license from the government of Bangladesh. BIAC has developed all the facilities required for arbitration and mediation proceedings. BIAC has its own arbitration and mediation rules. Apart from facilitating arbitration and mediation, BIAC also provides training courses on ADR, special arbitration, mediation, and negotiation to develop a pool of human resources in its field. Since inception, BIAC has been working hard to create awareness about ADR methods by conducting several outreach programs, seminars, workshops, dialogues, and webinars. In 2020, BIAC have launched an inter-university arbitration contest 2020 for the first time for students of law of Bangladeshi universities. In 2021 and 2022, the contest was more broad-based by participation of 8 leading universities from Bangladesh and abroad. The contest aims to acclimatize the participants with the theoretical and practical knowledge of the arbitration process and groom them to be better equipped in the professional in the future. This year, BIAC is hosting BIAC International Inter-University Arbitration Contest 2023 for the fourth consecutive year. Prestigious universities from country and abroad are participating in this contest virtually. In each round, every team will consist of 4 to 6 students from each university. Will be comprised of students with the roles of coordinator, counsels, and witnesses of their respective sides. 6 minutes have been allocated for each team to present their cases. Today is the fourth session of the preliminary round of this contest. Session, we have Sonargaon University as claimant and Independent University Bangladesh as the respondent team competing against each other. Before we move on to the main contest, it's my pleasure to introduce the 6 participants from Sonargaon University and 5 participants from Independent University Bangladesh. Representing Sonargaon University, Mohammad Abu Selim Tohid, Alindia Bishas, Mohammad Iftarul Alam Hasib, Moriam Akhtar Min, Sheikh Naim, Tabassum Habiba Oshir. Representing Independent University Bangladesh, Jannat Sochi Mem, Rudra Mohammad Shalam Parvez, Faim Shahriar, Sadia Afri Ani, Mohammad Ilyas Hossein Choudhury. Both teams already submitted their submissions to the arbitrator of the session and the other party. We have already circulated the program of the session. I request our today's arbitrator to strictly follow that program schedule, especially the time slots. This is to ensure that both parties get equal opportunities. I would like to start the event by introducing Chief Executive Officer of BIAC, Mr. Kaiser A. Choudhury. Mr. Kaiser A. Choudhury joined Bangladesh International Arbitration Center BIAC on 1st February 2022 as its Chief Executive Officer. Mr. Choudhury holds a master's degree in economics from the University of Dhaka as a professional banker, having started his career with Greenleaf Bank 70. Several senior positions in the banking industry, including positions of Deputy Managing Director and Managing Director of the country's 3 commercial banks, and also officiated as the Principal of Training Institute of Dhaka Bank Limited. He is in the board of Premier Bank Limited as its independent director. Request Mr. Choudhury to deliver his welcome address. Just wait a minute. Just wait a minute, please.
Thank you, Mohit. Sorry for this technical interruption. Thank you. Thank you, Mohit.
Thank you, sir.
Colonel Dinesh Kumar Bishnoi, arbitrator of today's session. Distinguished guests and dear participants from Srinagar University and Independent University, Bangladesh. Good afternoon to you all. It is indeed a great pleasure for me to welcome you all to the BIAC International Inter-University Arbitration Contest 2023. It is my privilege to extend our gratitude to the BRAC Bank PLC, Mutual Trust Bank Limited, and IFIC Bank for stepping forward to sponsor this important event of BIAC. It is a matter of great pride for BIAC that it is hosting the BIAC International Inter-University Arbitration Contest for the fourth consecutive time for university-level students, with an aim to acclimatize the participants with the theoretical and practical knowledge of the arbitration process to groom and shape them into better equipped legal professionals. Moreover, in the course of this contest, students will get an opportunity to acquire practical knowledge of alternative dispute resolution and develop necessary rhetorical skills, and furthermore, stand to benefit through the receipt of advisory notes from top regional and global professionals in the field of ADR. In line with the last year, or the previous year for that matter, BIAC is hosting the contest with the enthusiastic participation of international and national students, this time with the participation of 8 prestigious universities. BIAC is the first arbitration institution of the country. It is registered as a not-for-profit organization and commenced operations in April 2011 under a license from the government of Bangladesh. The International Chamber of Commerce, Bangladesh, Dhaka Chamber of Commerce and Industry, and Metropolitan Chamber of Commerce and Industry, Dhaka, are the sponsors of BIAC. The International Finance Corporation, the private sector arm of the World Bank, with funds from UK Aid and European Union, has supported BIAC at the initial stages under a cooperation agreement. BIAC provides a neutral, efficient, and reliable dispute resolution service in this emerging hub of South Asia's industrial and commercial activity. BIAC aims to embed the use of ADR as a commercial best practice to facilitate creation of an ecosystem that fosters investment and is conducive to business. It is committed to be a credible and a sustainable national institution that aims to offer international commercial best practices on ADR service to individual and institutions seeking to resolve commercial disputes. Since its inception in 2011, BIAC has been recognized by 62 national and international institutions, including the Permanent Court of Arbitration, The Hague, the Netherlands. BIAC offers membership to practitioners, stakeholders, students, and interested individuals at home and abroad to create a knowledge and resource sharing platform. Since its inception and until November 2023, BIAC organized 163 outreach programs and several seminars, webinars, workshops, and dialogue sessions. BIAC also organized a national consultation session based on the request of the Law Commission Bangladesh on proposed Arbitration Amendment Act 2018 by the Law Commission Bangladesh. And the recommendations from the session on the proposed Arbitration Amendment Act 2018 have been sent to the Commission. BIAC has proposed to the University Grants Commission and the Bangladesh Bar Council to include ADR in the curriculum in order to raise awareness and popularize the alternative procedure with the country. UK Foreign and Commonwealth Office recognizes the role of BIAC, and as evidenced in their publication, Bangladesh Doing Business Guide. And this guide is for British businesses who are interested in developing their overseas trade in Bangladesh. US Embassy in Bangladesh also recognizes BIAC as a forum for resolution of US citizens' trade disputes and has enlisted BIAC in their list. We are humbled once again by the generous contribution and support extended by BRAC Bank PLC, Mutual Trust Bank Limited, and IFIC Bank, the Academy, and the participating students to make the contest vibrant, interesting, and successful. Thank you all, and best wishes to the participants, and may the best team win. Bye-bye.
Thank you, sir, for your valuable speech. We are extremely honored to have with us Colonel Dinesh Kumar Bishnoi, sir, as arbitrator of today's session. May I introduce Colonel Dinesh Kumar Bishnoi, sir. Colonel Dinesh Kumar Bishnoi is registered with the Bar Council of Maharashtra and Goa and now practicing at Bombay High Court, Mumbai. His core areas of practice include contractual, commercial, construction, and maritime arbitration. Bishnoi has been sitting as presiding arbitrator, sole arbitrator, and coordinator in number of arbitral tribunals, having been appointed by honorable high courts, ADR institutions, reputed law firms, and also by eminent parties. He has been empaneled as an arbitrator in several international ADR centers and also achieved accreditations from different ADR institutions. During his entire distinguished and illustrious career for 40 years, he has been awarded twice by the Honorable President of India. He has completed his Bachelor of Law in International Law and other laws apart from diploma in senior level defense management. He retired as Colonel from Indian Army. Now it's time to start the contest, and I would like to hand over the stage to the arbitrator of this session. Best of luck to both the teams.
Thank you so much.
Thank you, sir.
And I'm privileged and honored to have been invited and to be here with you all for this session. ADR community is a global village, and we keep on meeting each other online and offline in various capacities and occasions. So I can see the restlessness of the participants for quite some time. So let us start. All the housekeeping rules are known to you. Program is known to you. And please feel free, frank, and at ease. And you may now start, and I hope somebody is keeping a track of time and somebody will be reminding. Wish you all the best.
Am I audible? Greeting to the members of the Tribunal for Arbitration and the Councils. I'm Tawassum Haiba Oishi as a co-ordinator of the claimant representing the Sonargaon University. All the team members will be taking 10 minutes each. First, we have Moriam Mim as the opening counsel as well as the examination in chief for the first witness. Then we will have Mr. Abu Selim Tawhid as the examination in chief for the second witness. After this, we will have Mr. Iktikharul Alam Hasib as the close as the cross-examiner as well as closing counsel. Lastly, the witness number 1, Anthony Davis, will be represented Mr. Sheikh Naim, and the witness number 2, Ramina Agharni, will be represented by Mr. Anindu Bishwas. Thank you.
Good afternoon, Honorable Tribunal. Before starting the process, we would like to am I allowed to raise the objection? Honorable Tribunal, am I allowed to raise the objection?
I don't see anybody raising hand. I don't think they have any objection. So we may proceed.
Honorable Tribunal, I am the examination in chief from the claimant. We have an objection.
Okay, please proceed.
Sir, when we are we got the file of the respondent, there was no witness mentioned in the file. Now we are seeing they are asserting witnesses. So it is not allowed to asserting witnesses beyond saying.
Okay. May I give the opportunity to the other party to please respond?
Mr. Arbitrator, as per the arbitration rule, BIAC arbitration rule 2019, Article 12.6, the respondent may introduce new witnesses during the tribunal proceedings. So there is no ground of objecting while we are introducing the witnesses.
All right. Do you want to rejoin, please?
Yes, sir. Sir, as we don't have any statement of the witnesses, we will have problems to cross-examine.
Our witnesses are always ready to assist you at any time, at any. You may ask our witnesses any question you want, and they are willing to answer it accordingly.
Sir, may I proceed with my opening statement?
Yes, please.
Good afternoon, sir, Chairperson, Honorable Tribunal, and opposing counsels. I am representing the interest of the claimant, that is the Capital Connection Co. Limited, as the opening counsel and as well as the examination in chief. In this opening statement with regards to the present matter before the tribunal, I will be stating the claims of the claimant. My first claim is the arbitration tribunal has jurisdiction to hear the dispute. It was clearly stated in the Article 7.1 of the deed of agreement executed between the claimant Capital Connection Co. Limited and the respondent Fiscal Sense Limited that in case of any failure to settle the matter amicably, such matter shall be referred to Bangladesh International Arbitration Center. And as our claimant has filed a default notice before the respondent and there was no response from them, it opens the doors of jurisdiction to for hearing the case of BIAC. Moving forward to the claim number 2, where the respondent failed to perform the agreement, not fulfilling conditions for obtaining the NOC, facing termination by BEPSA, likely not meeting the agreed upon timeline for handover and the handover of the assets. It is stated by BEPSA that Fiscal Sense failed to fulfill these conditions. The failure indicates breach of agreement terms. Capital filed a default notice on December 12, 2021 due to the failure to reach the stipulated timetable and demanded compliance within 15 days period. Fiscal Sense did not correct the defaults specified in the default notice. Also, the Article 4 of the deed of agreement, it states that The total handover and takeover process shall be completed on or before December 2021 from the date of stating of the agreement. The respondent failed then claim, I am moving forward, the claim number 3. The respondent as the respondent couldn't perform the agreement is a breach of contract. The claimant already paid 60% of the total value of purchase amount as per the article 3.2, and the article 3.3 of the deed of agreement says that the due 40% of the paid amount will be paid after the handover and of the possession and all original documents related Schedule A and B, obtaining possession, handover certificate, and lease transfer confirming from BEBSA, actual handover of the complete possession by BEBSA authority, and removal of such buildings. There are also issues that the total handover and takeover process should have been complied on before December 2021. But the Fiscal Sense Limited failed to do so. That means it is evident that there is a breach of the agreement. And jumping to the claim number 4, that the respondent is bound to pay BDT 2 crore 60 lakhs 58,240 takas. Because of the breach of contract, the claimant had to face various types of losses. They are as following: capital could not be able to start the desired project in time. As the capital could not start the desired project in time, it could not able to maintain commitment with their business stakeholders. Confinement of the capital money by the Fiscal Sense was stuck there. Claimant could not start their production in time, therefore they had to free irreparable financial losses such as interest in investor money and project-related consultancy charge. So the respondent, as the claimant has faced various types of monetary losses, the respondent is bound to pay the compensation. And also the 60% advance. Coming to the claim number 5, the respondent has violated the good faith and fair dealing in the agreement. Talking about the good faith, commands the parties cooperate in the procedure that the parties must provide truthful responses and informations, not use the document production as a means of obstruction proceed. So where the agreement says that the respondent has to obtain the NOC from BEBSA. As the BEBSA terminated the NOC, this violates one condition of the agreement, and also as the possession were not handed over in stipulated timeline. This is also another violation of the deed of agreement. So here we can say that the respondent has not acted in good faith in this performing this agreement. Then jumping to the claim number 5, that claimant, the respondent cannot claim the counterclaim, that as the defaulter is the respondent, there is no scope to claim the counterclaimed money. And the BEBSA, as the BEBSA allotted the lease property to capital following due process of law, there is no question of conspiracy or anything else. So The claimant respectfully requests the tribunal to declare that the BIAC arbitration tribunal has the jurisdiction to hear the dispute, to declare that the respondent failed to perform the agreement, and declare that the claimant solicited the tribunal to order the respondent to pay the claimant, therefore humbly submits the total claim of BDT 2 crores 60 lakhs 58,240 takas. Thank you. If there is no questions, may I go the examination in chief for the first witness?
Yes, please proceed.
If I am allowed, sir, may I call our first witness, Mr. Anthony Davis?
Yes, please proceed.
Mr. Anthony Davis, am I audible to you?
Yes, I can hear you.
Yes, so Mr. Anthony Davis, please introduce yourself.
I'm Anthony Davis, Managing Director of Capital Connections Company Limited.
Okay, Mr. Anthony Davis, how long you are doing your business?
I am doing this business for 15 years.
Yes. How do you know fiscal sense?
Yes, as we believe in good business practice, and therefore we had our business development officer, Romina Agharni. It is very much our duty to search for every sources of business in future and for present also. And from Romina Agharni, I could hear about fiscal sense, that fiscal sense want to sell its assets. Therefore, we connected to fiscal sense.
Okay. How the dispute arises between capital and fiscal sense?
As I said, that we signed a memorandum of understanding between fiscal sense and capital, and fiscal sense, following that memorandum of understanding, we also signed agreement. Therefore, fiscal sense had to hand over the possession that we purchased from them by December 2021. But fiscal sense applied for NOC from BEDSA on 11th of January and 2021, and then fiscal sense got the NOC on 27 February 2021. The NOC, it was a conditional NOC, and two conditions were attached there, but fiscal sense did fail to fulfill that condition, and then fiscal sense never hand over the possession to us, and we had to give notice of default, and then there was no compliance by fiscal. Can you hear me? Okay. Then after the default notice, fiscal sense never rectify the defaults set out in the default notice. So this means that we are in a deadlock situation, and this situation need to be set out, and need to be we need to get rid of this situation. Basically, then we had to we had to terminate the agreement of fiscal sense. Thank you very much.
Did you send any default notice for this dispute?
Yes, we sent a default notice upon fiscal sense on 12th of December 2021.
What was the response from respondent?
As I said, and as I mentioned, that there was no compliance by fiscal sense to rectify the defaults set out in the default notice.
Mr. Anthony Davis, did you paid any advance payment to fiscal sense?
Yes, we paid consideration for the transaction in advance, which was about 60% of the total amount. And
did fiscal sense receive the money?
Yes, fiscal sense did receive the money from us, and it was received by 2 checks dated on 7th September 2020, and the last check was 6th August 2021.
Okay, did you face any consequences for this?
Yes, it has been a very long consequences and very disturbing consequences for us as our money has been locked there by fiscal sense, and we couldn't develop our business, and we just start our project, and there are so many stakeholders. They are doing a business with us. We could not make the commitment with them. So these are the basically this type of problems that we are facing.
Okay, thank you, Mr. Anthony Davis. So now, if there are anyone for cross count.
Am I audible?
Yes, I can hear you. But if you could speak a bit louder, please.
So Mr. Davis, on September 3rd, wait a minute. So September 3rd, 2021, deed of agreement with fiscal was signed. Is that right? Capital signed a deed of agreement with fiscal. Is that right, Mr. Davis? Am I audible, Mr. Davis?
Yes.
Can you answer the question? Should I rephrase my question?
I can hear you right now, but I wish if you could. Yes.
Okay. So on September 3rd, 2021, Capital.
Hello.
Mr. Davis, can you hear me? Am I audible to you? Mr. Davis?
Yes, I can hear you. Please tell me.
Okay. So on September.
Now I can hear.
Okay. So September 3rd, 2021, a deed of agreement was signed with fiscal. Is that correct? I guess there was technical issue. Mr. Arbitrator, shall we wait?
Anthony Davis, can you hear me? Yes, I'm here. Please, you can ask me questions.
Okay. So, Mr. Davis, on September 3rd, 2021, a deed of agreement was signed with fiscal. Is that correct? Can you answer me?
Yes, it is true.
Okay. So can you tell me if all parties were physically present when the agreement was signed? Mr. Davis? Please answer me in yes or no.
I'm sorry, I didn't get your question. If you please.
If all the parties, there are 2 parties, right? Fiscal sense and capital. where the parties were informed during the signing of the agreement.
Honorable Sir, Arbitrator, we are extremely sorry for the inconvenience. Yes, we are switching our network.
Should I proceed with the questions?
Sorry for the inconvenience for technical issues.
So can I proceed? Mr. Davis, you're just wasting our question. Mr. Davis?
Give us only 1 minute, please.
You are
Honorable Sir,
our
Arbitrator.
times.
No, please take your time. I'm not granting.
We are switching the network, please.
Okay.
Please
give us 1 minute. Honorable Sir, Arbitrator.
Please take your time. I'm not granting any adjournment. Please fix the issues and carry on. I suppose the issue is fixed. You may ask the question again.
May I proceed, Mr. Arbitrator?
Yes, please.
Much obliged. Mr. Davis, can you hear me?
Yeah, I can hear you.
Mr. Davis, so I guess I'm skipping the first question, and can you clarify that, okay, so your company issued the notice of default on December 12, 2021. Am I correct? Mr. Davis? Am I audible, Mr. Davis? Mr. Davis, if you do
sorry this inconvenience, we're having a technical issue.
Sorry, I cannot hear you.
Just 30 seconds.
Yeah, please take your time, fix the issue and resume. I suppose witness is able to hear now.
Yeah, Can you hear me?
Yes, I can hear you. Am I audible to you, Mr. Davis?
Okay.
You are not clear.
I'm
not hearing you clearly.
for the inconvenient.
Okay. Mr. Davis, can you hear me?
Yes, I can hear you.
So your company issued the notice of default on December 12, 2021. Am I correct?
Sorry?
Your company issued the notice of default on December 12, 2021.
Yes, right now. Right now. Right.
Okay. So can you clarify what's this? Mr. Davis, can you please clarify what specific breaches of obligation by fiscal sense led to this default notice?
Okay, because as fiscal sense was supposed to hand over the possession by December 2021. And there was no initial steps was taken by the fiscal sense.
And we felt very much pressured, and that's why we gave them the default notice to settle the issue, and there wasn't any reply of the notice.
So you are saying there was not any reply. Fiscal sense did not cooperate with you. Is that what
we were not entertained. Yes, fiscal sense did not cooperate with us.
Okay. So
we tried to contact with fiscal sense so many times.
And can you please tell how did these breaches deviate from the agreed upon term? How did these breaches derive from the agreed upon term? Can you please clarify?
Fiscal sense was supposed to hand over the position to us. Things hand over possession certificates to be obtained by finally by BEVSA, and the buildings to be removed. These
that's now, Mr. Davis.
Were not done
by the. I got my answer. Thank you, Mr. Davis. So my next question is, you claim that Capital made 60% advance payment. Am I correct?
Yes. Okay. Yes.
So if Fiscal Sense's bank account were indeed frozen from December 14, 2018, as claimed by Fiscal Sense, so how did the Capital manage to make 60% advance payment during this period?
We have got money received from Fiscal Sense. We have paid the advance by account paycheck, and in that check there was a name of the Fiscal Sense. So there isn't any scope that the amount won't go anywhere except Fiscal Sense.
Okay, so you paid it by check, not in cash. Is that correct?
Yes.
That was an account paycheck. Am I correct?
Yes, account paycheck.
So Fiscal Sense's bank account was frozen. So if you pay the amount in check to the frozen bank account, so it would not be deposited. Am I correct?
We were not known of it that there wasn't any account.
I want an answer, yes or no. It's a direct question. Any money would not be deposited if the bank account was frozen. Am I correct, Mr. Davis? Please answer in yes or no.
I guess it might be deposited if it is frozen also.
So that's an yes.
Yes.
So, Mr. Arbitrator, with this is clear that the check was never deposited as the bank account was frozen. So, let's move on to the next question.
Yes,
Mr.
please
Davis.
carry on.
Mr. Davis. So you are saying you are not aware of the ongoing dispute. Am I correct?
I haven't said that I'm not aware of the ongoing dispute.
So you were aware of the ongoing dispute between Fiscal Sense and the custom bond dispute. You were aware. You just stated that you were aware.
I wasn't aware of that.
But you just stated, Mr. Davis, you just stated that you were aware of the dispute. So let's move on to the next question. So there is no question regarding this matter, as you have just stated that you were indeed aware of the custom bond dispute. So
I have never said that I was aware of the
Mr. Davis, you just stated that. You cannot change your statement. Okay. So that's my next question.
I guess it might be some technical problem.
There is no technical problem. I can hear you just clearly. I can just hear you clearly, Mr. Davis. I can hear you clearly. Thank you. Let's move on to the next question. You claim that the Fiscal Sense failed to fulfill the obligation Is that correct?
Yes.
Yes. So did you try to resolve this issue through negotiation?
Yes, that's why we send them the default notice, and there was no compliance
so can you
by the fiscal sense.
Okay, I got you. I got you, Mr. Davis. So can you clarify what substantial effort did Capital undertake to resolve the dispute? What did you do to resolve the dispute? Before coming to this arbitration tribunal, what did you do?
First of all, yes, you can take it as consideration of amicable settlement, because by December 2021, there was no initiative was taken by fiscal sense, and we are very much concerned that fiscal sense was fiscal sense was failed to perform the agreement. That's why we send them first default notice to settle the issue amicably, and
Mr. Davis,
then after
I got my answer.
And
so,
then my then my
Mr. Davis, I got my answer. So here the handover and takeover was supposed to completed by December 2021. Am I correct?
Yes.
Yes, that's correct. So you published a default notice on 12th December. Am I correct?
Yes. Yes.
So and after that, BEBSA terminated the lease, and after hearing that they were auctioning the property, you just participated in the auction and got the lease property. Am I correct?
It was basically not like that, because fiscal sense was supposed to fulfill the condition as
that was not my question, Mr. Davis. Did you participated in the lease and got
yes,
the property?
I'm coming to your question. I'm coming to your question.
Can
As
you
a
please
fiscal
just
sense
answer
did
my
not
question?
fulfill the condition which
you're just wasting my time. I just want my answers. This is a cross-examination, so I just want a direct answer.
Tell me.
So you did get the property. Am I correct? Did BEBSA give you a possession handover certificate, Mr. Davis?
Becoming aware of the fact that BEBSA terminated the lease of fiscal sense, and
Mr. Davis, it was not my question. My question was, did BEBSA give you the possession handover certificate after the auction?
Yes.
Okay, that's it.
Yes.
So you did get the possession handover certificate, and you had you have actually the possession of the property. That's correct?
Possession handover certificate.
Got the possession handover certificate, so you have the right to the property. Am I correct? Yes or no? Please answer in yes or no.
Yes, we have.
Okay.
We have.
Thank you, Mr. Davis. That's
yes,
all.
We have.
The difference will now rest.
Honorable Chairperson of Arbitration Tribunal, MI Counsel Abu Salim Tawhid, if you permit, may I examine my second witness, Ms. Agharni, who is the Business Development Officer of the Capital Connection Company Limited.
Yes, please go ahead.
Much obliged. Hello, Ms. Agharni. Am I right? You are Ms. Agharni? Yes, you are audible. Please introduce your professions.
Excuse me, my microphone. Romina Agharni, and I am the Business Development Officer of Capital Connection Company Limited.
How long have you been working in this sector?
Well, I am into this field for almost around 20 years, and around 8 years with the Capital Connection Company, to be specific.
What is your job responsibility?
What is your job responsibility? Here, my job is I have ex officio responsibility to work for the capital with my utmost sincerity and best efforts to develop business function.
How did you involved with the agreement which was signed on?
Which was signed on 3rd September 2021. I was engaged to prepare the agreement which was signed in Dhaka on 3rd September 2021. I was informed that Fiscal Sense Limited decided to sell all its assets as stated in the agreement. Thereafter, our company decided to purchase the said assets, and I was in a key role as part of my official responsibility to do needful from our end for the execution of the agreement.
Pay any consideration?
Did you pay? Yes, Mr. Counsel, as it's already stated in the case fact, we do amount that is US dollar 288,000, which is in Taka 2 crore 24 lakhs 64,000, and it's already mentioned in the article 3.2 of the agreement.
Do you have any documentary proof?
Yes. Yes, Mr. Counsel. We have got copies of both the checks, which we deposited at the exhibit number 1 and 2. And we also have the money receipts from Fiscal Sense as given in exhibit number 3 and 4, dated 7th September 2020 and 6th August 2020. Perfectly admitted received our advance amount.
When inaction from Fiscal Sense was what was your role at the time?
Well, when this kind of unwanted circumstances were started to create, I tried my best to avoid the same and to do needful to execute the process from our end. I communicated each and every time to the Fiscal Sense and requested them to be more active to expedite the process.
Did you warn Fiscal Sense about the violation of the deed agreement? What was their reply?
Yeah, several times. Since Fiscal Sense was failing to deliver the assets of to us within the stipulated timeline, unfortunately, there was no compliance by Fiscal Sense to rectify the defaults set out in the default notice as given in exhibit number 5.
Does Capital Connection Company suffer any losses due to Fiscal Sense?
As per the Article 4.1 of the agreement, Fiscal Sense was bound to complete the total handover and takeover possession on or before December 2021 from the date of signing the said agreement. But Fiscal Sense failed to perform the agreement, and the in consequence, our company has been suffering for huge monetary loss and various aspects. Because of Fiscal Sense, we could not start our project in time.
and thus could not able to maintain commitment with our business stakeholders, they confines our money. That means fiscal sense, and without delivering the assets, we could not start our production in time. Therefore, we had to face irreparable reputational and financial losses, such as investors' money and of the interest and project-related consultancy charges, project under cancellation, and other legal expenditure. We have our project consultant, marketing consultant, commercial manager, and a few other personnel who are employed only for the said upcoming project. These are incurring huge cost every month because of their inaction and non-performing the deed agreement. We used to reserve a book capacity from all of our stakeholders for the successful execution and functioning of the plant project. Due to the deadlock circumstances, which was created by the Fiscal Sense Company Limited of our plant project, some of our stakeholders penalizing us, some of them putting pressure to keep our commitment regarding the fulfillment of yearly projection. I communicated to Fiscal Sense every time, but every time they avoided me, which resulted in serious pathetic circumstances for us.
Thank you. What was your initiative to settle the dispute?
Yes, I tried to communicate with Fiscal Sense frequently during this whole time. I personally went to their office several times. I personally told their MD to do the needful to execute the entire process, but he tried to avoid his time, unfortunately.
Why did you terminate the agreement with Fiscal Sense?
See, according to the deed agreement, Fiscal was to hand over us the assets within December 2021. Not only they failed to perform the agreement, but also no such part performance was shown from them to execute the entire process. Moreover, on 15th July 2022, BIAC terminated the lease because of their failure to complete the selling procedure and for not clearing BIAC dues. Observing all these circumstances, we had no other way but to terminate their deed agreement according to the Article 8.1 of the agreement, which clearly gives permission to both parties to terminate the agreement if there is any default made by the other party. So yes, on 15th November 2022, we served our termination notice to Fiscal Sense as given in our exhibit number 9.
Did your company follow the valid procedure to get the lease handover from BIAC?
Yeah, sure. While getting the lease from BIAC, that's then we were like independent purchaser. And on 15th July 2022, BIAC terminated the lease of Fiscal Sense, citing several grounds, including the failure to complete the formalities of the selling procedure, as stated in BIAC NOC. On 15th November 2022, we having become aware of the fact of the termination of lease by BIAC, served our own notice of termination according to the clause number 8 of our deed agreement. And BIAC published a notice of auction in the Financial Express newspaper, and we just participated there and we won the bid, and we got the lease, but still we got the handover certificate. We never take the physical possession of the property.
What's the overall impact for your current situation?
Overall impact? The situation is shocking. The overall situation very pathetic. Like our production is stuck, GDP growth is stuck, unemployment problem. This is of course an unhealthy practice in business ground, and which is ultimately bad for the society, to the good purchasers for this, and this is not a good practice in contract area or in business area.
Thank you very much. No further questions. If our prosecutor have any question to
our witness, they must.
Mr. Romina Agrani and Honorable Arbitrator, am I audible?
Yes, please. Do not ask again and again.
Mr. Counsel.
Audibility. If you are not audible, you will be told. Kindly carry on, please.
Much obliged, Honorable Arbitrator. So, Mr. Romina Agrani, as you
Yes,
have
Mr.
stated, that you sent fiscal sense a default notice in exhibit number 5. Can you tell me the date of the sending date of legal default notice?
I think you have already answered in your question, if I am not wrong.
Can you please tell me the date? In which date you, Capital Connection sent the default notice?
The default notice, I can't remember actually right now. The date is very much difficult to remember, you know.
It was
and
prior.
I can search for this, but
it
is
was
this, so relevant.
Yeah. It was prior from the completing date of the takeover process. Okay, that completely takeover process date was December 2021. That means 31st December was the deadline of the takeover process. Okay, but Capital Connection gave the default notice before the extended date. So my second question is, as you have said, you communicated to fiscal sense every time to do needful to comply BIBSA's condition. Do you have any proof that you tried to communicate with Fiscal Sense Limited?
Yes, we have proof, already we have given in our witness statement number 2. All right.
Do you have an exhibit? Do you have an exhibit?
Yeah. My statement as a my statement is already given in our exhibit number 2 in the witness section.
It's just a fictional statement. Okay. I am asking for the exhibit. Do you have any proof that you tried to communicate with Fiscal Sense by email or through by any other communication process? Yes or no? Just answer me on yes or no. It's a direct question.
Every time it cannot be answered in yes or no, because it could be
Please,
misleading.
I need this answer only on yes or no.
Yes,
not the description.
Yes, I communicated with your MD personally few times.
Okay. Almost every and you also have stated that also almost every time Fiscal Sense avoided you, which resulted serious pathetic circumstances for Capital Connection Company Limited. As a business development officer of Capital Connections Company Limited, didn't you have the knowledge that the account of Fiscal Sense was frozen from 2018?
I didn't know, but see, I want to expand a bit in this case. Account frozen means it's a mere allegation by Fiscal Sense.
How
I don't believe that Custom Commissioner.
Dear witness, honorable witness, I want to say that how it can be a mere, because it is totally stated in the fact that since 2018, the account of Fiscal Sense was frozen. And you, past witness, have already stated that he had the concern about the frozen account. How can you deny it?
See, I can deny, but because it's your perspective actually, since it is written in the fact, but it's totally your perspective. And let me see, let me finish, please, Mr. Counsel.
Yeah.
See, a company can have multiple accounts. And the allegation was like your company's bank account was frozen by the Custom Bond Commissionerate. But in the practicing law, there is no such judicial precedent or any such type of like a statute that custom commissioner has the capacity to freeze any account without the permission of the court.
Okay.
And may I
okay. I
counter
got your
question,
answer. I got your answer. I got your answer. Please. So you said that a company have multiple accounts. So you the Capital Connection Company Limited gave Fiscal Sense an account pay check. Is it correct or not? Yes or no? So
yeah, it's correct.
In the account pay check, the money will be transferred direct to the account. It not will be in cash. Okay. So if the account of the Fiscal Sense is frozen, so how the amount will be deposited to the bank account? And it cannot be transferred.
Yes, Mr. Counsel, you are asking the same question in different words. See, I already told you that a company have multiple accounts, but already in the fact, it is also stated that you guys already admitted the 60% of our deposited money, and you guys also provided us the 2 money receipts.
Okay.
All right. So what about that?
2 money receipt. The money receipt was only for the check, not for the deposit. It was not the deposit slip. It was the slip that we received the check, but we didn't deposit it because our account was frozen since 2018, and Capital Connection have the full awareness about our frozen account.
No, we didn't know, and you also didn't inform us that your
listen.
But
it was
after the dispute, you were making a story.
Direct.
Actually,
it was direct account paycheck, so we can't deposit it on our another account. If we have another account, we can't deposit it.
What you say? What is your proof that you couldn't deposit it or whatever? Why didn't you inform us before that your account was is frozen or what type of?
Fiscal Sense.
And your mere allegation is totally baseless.
Capital Connection.
Capital
Connection have the full acknowledgement that Fiscal Sense account was frozen since 2018. Okay, so as a business development officer of Capital Connection Co. Limited,
have the awareness that you guys have a dispute with the Custom Bond Commissioner. I think we just have that kind of awareness.
So,
and do you know the system of a valid seller and valid purchaser, bona fide seller, bona fide purchaser? Then you guys have to aware us before the agreement that you had a transactional problem or something like that. That also didn't you inform us? How about that?
So, in this said agreement, buyer should be aware about the bank account. Okay, so Fiscal Sense can fulfill the conditions of BEPSA to get the NOC, where Fiscal Sense could not do any bank transaction. Okay, so the bank transaction couldn't be finished because of the dispute between BEPSA and BEPSA and Fiscal Sense.
I got. Okay, I since the time is
so
very low.
So
it was
my
question.
So it was
okay.
It was my cross examination.
Your observation, right?
So
no.
Thank you.
You can't let me finish. Just that's it. I need to.
I'm examining you.
Myself. See,
I got my answer.
In the last para of the fact, you
I
are
got my answer. Thank
claiming
you.
the remaining 40%. So without taking the 60%, how do you claim the remaining 40%? That's question up to you. All right. Thank you.
This is your show. So please come on in your turn, unmute yourself, take initiative and cover screen, please. And start the process.
Am I audible? Dear Honorable Arbitrator, a very good afternoon to you. I am Zakaria Islam and I am the coordinator for the respondent, Fiscal Sense Limited. This is an arbitration for settlement of the dispute between Capital Connections Company Limited, the claimant, and the Fiscal Sense Limited, the respondent. In such, the opening statement will be presented by Sadia Afrin Eni, who is the senior legal counsel, and she will be speaking for 10 minutes on the part of the respondent. The senior legal counsel will also contact the examination-in-chief of our first witness, Mr. Azan Rahman, for further 10 minutes. After the cross-examination by the claimant, the junior legal counsel, MD Ilyas Hussain, will conduct the examination-in-chief of our second witness, Almas Ahmed, for 10 minutes. After the cross-examination of the second witness, this will be followed by the arguments and summation by junior legal counsel, and he will be speaking for 10 minutes. With this, I will be closing my statement, and I would like to call upon our senior legal counsel to begin the arbitration process upon the permission from the Honorable Arbitrator.
Honorable Arbitrator, I am praying to you to give permission to ask a question, to raise a question. Sir Arbitrator, please.
Yes, please go ahead.
May I kindly know the name of second witness and his or her involvement with the dispute?
Yes, certainly. Our second witness is Mr. Almas Ahmed, who has been working with Fiscal Sense Company Limited as the head of accounts from 2016.
Head of accounts, right?
And he was a party to the deed agreement as a witness part of the Fiscal Sense Limited.
Okay. He was a signatory there to prepare the deed of agreement, right?
Yeah, that's correct.
As witness.
Yeah, he was.
Thank you so very much for informing us. Thank you so very much. Thank you, Honorable Sir Arbitrator, to give me the opportunity to get the information.
Am I audible? My name is Sadia Afrin Eni, and I'm the senior legal counsel for the respondent. Honorable Tribunal, since the claimant has already talked about the facts about the dispute, we'll just provide brief summary from the respondent's point of view. Fiscal Sense sought an NOC from BEBZA in January 2021, but failed to meet conditions, leading its termination by BEBZA in July 2022. The claimant terminated the agreement in November 2022. BEBZA auctioned the leased property and possession was handed over in March 2023. The claimant demands compensation, including 60% advance, interest, and cost of the respondent admits the agreement, but claims the balance is due and alleges collusion. Respondent counterclaims Taka 5,253,000 with 15% interest, denying liability for the claimant's demands. In answering the procedural issues, the respondent would like to highlight that the jurisdiction of the arbitration tribunal is under scrutiny due to the claimant's failure to pursue amicable settlement and breaches of procedural rules. The respondent's objections centered on this issue, introduce uncertainty regarding the tribunal's authority. And the substantive issue, the respondent argues that the agreement is void because conditions were not met, so there was no breach issue. The respondent argues that the contract frustration means there was no need for repayment, and Fiscal Sense defends itself, mentioning challenges like a frozen account for not getting the required NOC and denying any breach of good faith. A valid counterclaim by respondent alleges legal termination and seeks compensation for unlisted properties, and BEBZA's lease actions are questioned. especially considering fiscal sense's financial struggles and an alleged confidentiality breach. With that, Honorable Arbitrator, the Council would like to conclude its opening statement, and with your permission, would like to proceed with examination of the first witnesses. And relevant facts regarding substantive issues shall be reviewed through the examination of the witnesses and further substantiated by my counsel, Mr. Ilyas Siam, and his closing statement. May I proceed with the chief examination of our first witness, Mr. Azam?
Yes, thank you so much. Please proceed.
Honorable Sir Arbitrator, I would like to raise an issue here. Could you please allow me? Honorable Arbitrator, I'm praying for a permission to raise an issue. Could you please allow me? Honorable Sir Arbitrator.
Yes, please. Yes, please go ahead.
May I kindly know from the Council of Opposition that why it is stated that without having provided the witness statements, you will be lawfully allowed to examine your witness. May I kindly see or directed to the rules or law? Honorable Arbitrator, it is the very much ordinary course of action in court practices that the deposition of witness will be provided to the opposition. This is a normal custom, but we didn't have any deposition witness. Therefore, I would like to know the same. Thank you very much, Honorable Arbitrator, Sir Arbitrator. And I'm drawing your kind attention here.
Honorable Arbitrator, our teammates already answered the question. As per the rule, we are allowed to add any witnesses.
May I kindly know the rule number?
Can I finish?
May I kindly know the section? I cross-checked and didn't find any.
12.6.
Sorry? Pardon me? 12.6.
This objection was already cleared on the first part. You have already objected, and we just cleared.
Yes, we rechecked with the guidelines here. And we didn't find it. Honorable Sir Arbitrator, we rechecked with the guidelines
Arbitrator, we
and
have
we didn't find
answered the question. May I please proceed with the
Honorable Arbitrator? I'm humbly drawing your attention. This is a misleading and wrong information might be. With due respect, I would like to see the.
And I suggest the opponent to read the rules carefully. And please don't raise
yes,
your
rules
objection.
Number or section number.
I have already
Honorable
answered your question.
Arbitrator.
You're just now wasting my time. Can I please proceed? And if you have any further question, you
extremely sorry to create the inconvenience. Honorable Arbitrator, I am drawing your kind attention, humble attention. And now at this moment, I'm strongly submitting that this is the wrong information. Because we checked with the rules and didn't find any section over here.
You're not audible.
And this is.
You are not clear with your statement or your question, and I've already answered your question. So I would like to request.
Rule numbers, may I kindly know the rules number? I'm humbly requesting.
Mr. Azan Rahman.
Honorable Arbitrator, I would like to know the rule number, please, kindly. Section number.
12.6, and we have already given the answer.
Thank you very much. Okay. We are checking on second.
Thank you. Please check.
Honorable Arbitrator, the opponent has already raised that objection at the beginning of the session, and I don't think that they have, and I think that we have already cleared everything they have asked for, and we have also assured them that our witness will duly comply with all the questions, and they can take time to ask questions. And also, the council already stated the rule number, and they are just wasting our precious time and delaying the arbitration process. And and they can also ask, they can also raise the objection, and if it was a procedural objection, they can also raise it during the summation part. And I hope that the opponent has already got their answer, and please let us proceed with our first statement. It's a humble request to the claimant.
May I please call the first witness, Mr. Azan Rahman?
Honorable Arbitrator, I reject 12.6, but nothing is stated here in the rules.
You can raise your objection later on, and we have answered your question. So we would request not to interrupt our proceedings.
Okay, thank you very much.
Mr. Azar Rahman, am I audible to you?
Yes, good afternoon.
Good afternoon, Mr. Rahman. How are you doing?
Well, I'm Mr. Azan Rahman, the Managing Director of Fiscal Science Limited.
Mr. Rahman, can you tell me that did Fiscal Sense agree to sell their asset to capital? Is that right?
Yes, that's right.
Okay. Can you recall the date of the agreement?
Yes, it was on September 3rd, 2021.
So I see that you provided an indemnity to the capital. Am I correct?
Yes, that's correct. I provided an indemnity to the capital.
Was it given on behalf of the company?
No, the indemnity was provided personally by me, not in my role as a managing director of the company.
Okay, so you gave the indemnity on your personal capacity?
Yes.
Okay. Mr. Rahman, in your statement, you mentioned concerns about the jurisdiction. Can you tell the tribunal why do you think that your personal capacity should not be part of this arbitration? Briefly.
The indemnity was provided before the agreement, and I believe I am not personally involved in the agreement or arbitration.
Okay. So, Mr. Rahman, can you tell us, did Fiscal Sense applied for a no objection certificate?
Yes, we applied for a no objection certificate.
And what happened? Did Fiscal Sense get the no objection certificate?
No, Fiscal Sense didn't, because Fiscal Sense was facing some difficulties meeting the NOC conditions.
And why is that? What difficulties did Fiscal Sense face meeting the NOC objection?
Fiscal Sense had issues due to custom dispute and frozen bank accounts by custom since December 2018.
Okay. And capital claims collusion between BEBS and Fiscal Sense. And what is your response to these allegations?
I reject these claims and stating BEBS's actions were illegal, and Capital was aware of the custom dispute without addressing it fairly.
And they did admitted it. Okay. So Mr. Rahman, lastly, do you affirm the truth of your statement? Are you confident that the information you provided is correct?
Yes, yes. I am confident that the contents of my statement are true and correct to the best of my knowledge, belief.
Okay. Thank you, Mr. Rahman. The defense will now rest.
Honorable Arbitrator, now I would like to introduce the witness number 2 of the respondent side.
Honorable Arbitrator, I am seeking permission to cross-examine the witness number 1.
Yes, please go ahead.
Yes. May I kindly communicate it to witness number 1? Are you there?
Yes. Please ask.
Could you please introduce yourself?
Yes, I am Mr. Azin Rahman, the Managing Director of Fiscal Sense Limited.
Okay, if you don't mind, may I ask you that how long you have been doing this business?
For 10 years.
Okay, thank you very much. And what was the nature of your business?
As a position of Managing Director, my duty is to manage the whole office, and I'm dealing with different problems.
Please don't mind, I would like to interrupt. What was the nature of your business? That means what type of business you were doing at that time? That means type of business.
Sorry, Mr. Counsel.
Please be frank, be friendly, and if you don't understand any of my question, I will clarify more and more, okay? Sure. Just I want my answer. What was the nature of your business? That means what type of business you are doing at that time?
Yes, it's a private limited company. It's a private limited company. I'm the managing director. Shares incorporated under the company's.
Could you please precise? That means type of business like export, import, manufacturing, or other types. What type of business?
Manufacturing,
right? What was your targeted market?
Sorry, Mr. Counsel, I cannot assist you through this. It's not relevant to my statement.
Okay, we didn't get any statement. Therefore, we are asking, as you are MD, Managing Director, that means you will, please give me the floor, you will take your time. You should have think from a micro level, that means operate your business. Therefore, I'm asking you this question. What was your targeted business market?
I'm not willing to answer this question.
Oh, okay, thank you very much. And what was the product you are manufacturing? What was the product you are manufacturing there?
This is very confidential question about my company.
This is product confidential question, Mr. MD. If I know about your product, we may also somehow provide you some sort of marketing facility. We are in the same. Okay. Honorable Azan, why did you establish your business in the EPZ?
Please ask some question which is relevant to the fact.
May I kindly know the organogram of your company?
Please rephrase it.
May I kindly know the organogram of your company? That means managerial setup of your company.
The question is irrelevant.
This question is irrelevant. I'm not willing.
Mr. Azanur Rahman, you are since very young. Okay. And Mr. Azanur Rahman, EPZ provides, and it is a subsidized zone by the government, and government facilitate duty-free facility and subsidy for the export-oriented industry there. So thank you very much for a question. And may I kindly know the issues or problem you are suffering? What is your grievance? That means problem you are suffering right now.
As a managing director, we are claiming 40% money back.
And what is your problem? What is your sufferings? What is your grievance?
BIAC illegally terminated this, and I
okay.
Actually,
okay. Managing director, this is tangible or outcome. What was the root cause of your sufferings? Why do you suffer right now? Did capital connections create any unhealthy practice with you, or any problem or anything?
Solution between capital and BIAC.
Mr. Managing Director, did you receive any advance amount from capital connections?
We received just a check.
Okay, but Mr. I would like to draw your kind attention, page number 2 of the agreement, which was signed by you, and clause 3.2. You admitted the advance from there. Could you please direct yourself there? The purchaser has already paid 60% of the total value. That means USD 280,000 taka. US dollar was received by you. You admitted here. How do you just contradict with your statements?
We received 2 checks.
Not cash, right? Not cash, right?
Of the checks, not cash.
Okay. Mr. Azanur Rahman, as per the Money Laundering Prevention Act 2012 existing in Bangladesh, Section 14(6) allows the deposition of money in a frozen account. if anyone send money to the frozen account, money will be deposited. This is for sure. Your counsel may check my law point, and you are telling that you didn't receive the money, but you signed and admitted in the contract.
And there is no
evidence. Don't you think this is contradictory?
There is no evidence that we actually deposited the check.
Why did you inform the capital connections that there is some problem? You are not able to get the cash.
The capital already knew about our frozen bank account.
Do you have any documentary proof or evidence? This is a disputed question of fact. I am telling that you received, you are telling that you didn't receive. In this case, you're supposed to show some sort of documentary proof. Okay, I'm not telling that I'm correct. As well as the vice versa. Do you have any supporting evidence?
As you are claiming, that's your responsibility. As you are claiming that you are responsible for the production of
Azanur Rahman, their managing director. In case of civil matter, balance of proof is followed. In case of civil matter, in case of criminal matter, burden of proof lies on the claimant. But this is a civil matter, and you were our business stakeholders just a few days ago. Still, we believe. So we are seeking cooperation from you in this regard. Why didn't you inform us by any means, or why don't you have any documentary proof? Could you show any documentary proof? We are backing our statement with law and with documentary proof, which is stated in page number 2. But do you have any kind of proof, documentary proof in this case? We are requesting you to arrange. No. Okay. No. But we have documentary proof here. Page number 2 of the agreement, 3.2, article number 3.2. You admitted and you signed, here. Okay, and you didn't receive the amount, but in counter claim you asked just only 40% along with interest. Why didn't you ask the entire money? Could you please tell me?
We have already 2 checks. And
Mr. Azanur Rahman, we think that we are still your business stakeholders. No worries, be frank, be comfortable. Just we want our question, answer of the question. You are very young person. Future is all the future is remaining for you.
I'm comfortable with you, but you are asking some unrelevant questions.
This is very much relevant for me. Maybe for you this is irrelevant. When you are counter claiming, you were asking only 40%. In the counter several places in your submissions, in the admitted case dockets, problem, in the agreement, everywhere you asked only 40% along with interest. Why didn't you ask the entire amount?
As we already fixed for 60%, and that's why we are claiming 40% rest.
Sorry, could you please repeat?
As we have checks for 60%, and we are.
But as of you, please, sorry to interrupt you. As of you, the check was invalid. As of you, and it's 4 years gap. It's 4-year gap. And till today,
we didn't see. That
didn't?
Check was invalid.
You are not telling that check was invalid.
Right.
You are not telling that. But this check is unable to provide you cash.
You cannot deposit.
So what would be the identity of this check? Sorry?
We cannot deposit the check because of our frozen bank account. But we cannot.
But as per the guidelines of Bangladesh Bank, yes, all the banks of Bangladesh ruled under the guidelines of regulatory bank, Bangladesh Bank. Only BFIU can freeze the bank account with the permission of the court. customs authority directly, whimsically, arbitrarily freezed your account for 4 or 5 years, and you are still sitting here. What was your initiative?
We try to resolve the
we try out to resolve the problems, but they did not cooperate with us.
Illegally demanded.
How did you try?
And illegally.
Can you rephrase that question?
Oh, how did you try to resolve the pending issues with customs? Please, may I kindly know the export-import procedure from or the selling and purchase procedure existing in the EPZ area?
That's irrelevant. I am not willing to answer the question.
Mr. Azanur Rahman, respected managing director, this EPZ is like the another country in our country. Everything, if anyone want to sell and purchase, need to follow the due course as like export and import. And government each and every time encouraged to function any company situated in the EPZ, and GRS officer, grievance redress officer, dedicated to resolve any kind of issues there. Did you approach to them by any means?
We don't have any dispute with them. We have tried.
I am not aware of.
Okay. Could you please elaborate or tell at least a little about NOC related dispute or issues?
Sorry, can you please rephrase that?
Could you please tell us something about NOC related issues or problem?
Yes, we facing difficulties for getting the NOC.
NOC from?
NOC from BEBSA.
You told that for the sake of your inaction, NOC was getting invalidated, right? For the sake of your inaction, NOC was invalid, right?
Yes.
This kind of thing, right? You deposited in your submission, right? Mr. Azanur Rahman, if I am Muhammad Iftekharul Alam Hasib, just let for 30 seconds that your employee, I would like to visit India by taking NOC from you. No objection certificate, that means your permission. You told that Hasib, return India from 20th January of this month, and I failed to do the same. After returning, I told you that, sir, please don't penalize me because I violated the rules and your NSC was invalid. Did you get my point? Mr. Azanur Rahman, I would like to clarify you that for the inaction of you,
NOC, I will not be able to go.
If you don't get NOC.
Yes, yes.
But if NOC once issued to go India from you, and I went to India with conditions and I broke the condition, and after returning there I am telling that your NSC was invalidated.
This is not relevant to our facts.
This is very much relevant because for the inaction, I'm explaining within 10 seconds only. For the inaction of you, the NOC was given by the government authority, BEBSA. For the inaction of you, you are telling that NOC was invalid. BEBSA try in every means to cooperate you. And for the inaction of you, you are telling, this is like you get bowled out or I myself get bowled out. I'm telling that this playing is not by following the rules. That means if your superior or my superior provide me any facility, NOC means permission. Do you agree with my statement? NOC means permission?
Yes.
Yes. according to the fact, we really try to resolve the matter against BIPSA, but they illegally demand money from us.
NOC BIPSA provided Azanur Rahman, Sir Azanur Rahman, NOC provided you by BIPSA. You violated the condition, and you're telling that NOC itself is an invalid, right? Am I right?
No.
You had written this in your submission. You had written the same in your submission. You had written this. In the argument number 1, you had written this. You may cross-check, and you may request to cross-check this to your learned counsel. Mr. Azanur Rahman, if I am your subordinate, say for, and you granted or you facilitate me some sort of facility, and I myself violated the rules, and coming back to you, I'm telling that, sir, your facility was not good, or this blah blah blah. Your facility itself was invalidated.
Sorry, can you please rephrase that?
That means you are my superior boss. You are giving some sort of facility to me in written and with condition, and I myself solely violated the conditions and telling that, sir, your facility was invalid because of my action.
What's the question? Actually, what's the question?
Do you think that this kind of action is ethical or a healthy practice, saying this kind of statement?
Asking bribe is not a healthy practice as well.
So, may I kindly listen once again, sir?
Asking bribe is not a healthy practice as well.
No, I didn't ask any price or privacy. Just I was trying to clarify the fact. We are counsel, we are court officers.
I was saying bribe. Bribe.
Okay. Asking
legal money.
Bribe. That means. Okay, bribe. Who asked bribe to you?
BIPSA.
BIPSA. What was your action after asking the BIPSA? What was your custom? Do you have any proof that they asked bribe?
That was in the fact.
That was
described in the fact.
Oh, that is in fact, that was in the fact, I am admitting, but as disputed question of fact, in the form of disputed question of fact, not conclusive form of fact. Just second last pair of the last page of fact, that was as disputed question of fact. That means that fact, you are telling this and I am opposing, that this is disputed, this is not conclusive. Do you have anything, any conclusive evidence or anything to believe us that you are telling correctly or rightly?
Fact is not disputed, it's a conclusive fact.
How it can be conclusive? Because this is the case. Because here this is written as disputed. Could you please redirect yourself? Okay, Honorable Arbitrator, I am praying to you to give me some time as the case is clarified conclusively with this evidence. Honorable Sir Arbitrator.
We have to proceed as per the timelines given and proceed laid down.
Okay, Honorable Arbitrator. May I kindly my learned opposition, could you please present your second counsel? So, or second witness, sorry, second witness for examination in chief.
Honorable Arbitrator, now I would like to seek the permission to call my second witness. Mr. Witness number 2, please introduce yourself to our Honorable Arbitrator.
Hello, Councillor. I am Almas Ahmed. I am the head of accounting Fiscal Sense Limited.
As the accounts head of Fiscal Sense, do you know what is the relation between Fiscal Sense and Capital Connection?
As my primary responsibility is to maintain the accounts of Fiscal Sense, I acknowledge and testify that there was an ongoing agreement between Fiscal Sense and Capital Connections Company Limited for transferring the lease and selling certain assets as mentioned in Schedule A and Schedule B of the said agreement. Councillor.
Mr. Almas Ahmed, as an head of the accounts, as an head of the accounts, did you get any check from Capital Connection Limited?
Yes, as consideration under this agreement, we did get checks. Capital Connections and Fiscal Sense 2 paychecks. First was one 7 September 2020, and the second was on 6th August, and first one was valued 1 crore and 12 lakh and 32,000 taka, and the second was 1 crore and 12 lakh and 32,000 taka.
Did Fiscal Sense deposit the checks on bank account?
Honorable Arbitrator, no. Fiscal Sense could not deposit the bank was frozen by Custom Bond Commissioner since 2018. Capital Connections had knowledge about the Fiscal Sense Limited's account condition.
Mr. Almas Ahmed, as Fiscal Sense received 2 checks, did Fiscal Sense paid any receipts to Capital Connections Limited?
Yes, of course. Fiscal Sense gave them receipt for receiving the checks, but the money was never deposited to the account of Fiscal Sense Limited. Therefore, the Fiscal Sense gave them receipts for receiving the checks only.
So lastly, I want to just ask you that there were some dispute between Fiscal Sense Limited and Custom.
Yes.
Custom Bond Commissioner. Am I right?
Yes.
Did Fiscal Sense try to solve the bank matter, and did BIAC terminated the lease before settling this dispute?
Yes. Reason of bank account being frozen, there was ongoing dispute between Fiscal Sense and Customs. But whenever we tried to resolve the dispute between the Custom Bond Commissioner demanded money illegally. That one of the prime reasons that Fiscal Sense could not pay the dues and comply with the BIAC's NOC conditions. Without settling the dispute, settling the dispute, BIAC illegally terminated the lease and illegally allocated the said property and assets to the Capital Company Limited.
Honorable Arbitrator, that's all from the witness number 2 from respondent side.
Honorable Arbitrator, I am praying for permission to cross-examine the second witness of opposition.
Keeping in timeline, please proceed.
Okay. Could you please introduce yourself?
Yes, I am Almas Ahmed. I am the head of Fiscal Sense Limited accounts.
Okay. What is your job responsibility there?
I maintain all the accounts and money kind of transactions.
Okay. Confirming or ensuring receivable money is your one of the very much important responsibility.
Yes, of course.
Right? Okay.
Of course.
You are telling that you were unable to receive cash payment as the account was frozen. What was your act or initiative at that time?
At the time, we tried to contact with the commissioner of custom bond commissioner, but he demanded money illegally, so we couldn't go illegal ways.
Did you go to Bangladesh Bank cell, customer service cell or grievance redress cell, and inform them that your account is frozen? As a customer, you are seeking permission from them.
Councillor, that's very relevant from the case. It's not invested.
My dear honorable witness, you are suffering. You are not getting money, and you didn't go to the proper authority, and this is irrelevant. How this is irrelevant? When they were asking for a bribe and the proper forum to get the relief is Bangladesh Bank customer service. They are regulatory authority for banks.
This is fictional. This is a fiction. You cannot ask
Which
me
one is
questions.
fictional? Which one is fictional? You didn't go to the proper forum. Bank authority independently. Please give me floor and you will get your floor. Bank authority guided under the rules or supervision of Bangladesh Bank. Customs authority didn't have the lawful authority to freeze any account. So why didn't you go to Bangladesh Bank?
Fictional question, that's out of the facts.
That's a fictional question. That's out of the facts, Councillor.
If someone if accident took place and someone went to football field rather than going to hospital, and if someone asking that why didn't you go to hospital rather than going to hospital, you went to football field, and this is irrelevant question.
Yes, out of the facts. Yes, out of the facts.
Okay, thank you so very much. Okay, and what was your yearly turnover?
That's confidential. That's confidential. I cannot share that with you.
You are in a export-oriented industry, and this kind of industry needs to give all kind of information to maintain its transparency. As government provide subsidy, this is under Right to Information Act 2009. That's only turnover, not price. What is the price you are providing to your customer, quoting price? But your yearly turnover, as you are getting subsidy from the government, people has the right to get the information. What is your yearly turnover?
Yes, people have the right. Yes, people have the right, but it has to go through a proper channel. But it has to go through a proper channel. As far as I know, I cannot disclose it with you.
Okay. Okay. What are the other departments you are working with? What are the other departments you are working with inside your company?
I am only working with the accounts.
Do you have any relation with commercial department in your company?
No.
How you are performing your day-to-day tasks? Because commercial department is a must for export oriented firm. They are only they deal with the customs, only they receive proceeds, and they are the authorized media to provide you the cash for the company.
That's not our memorandum of article. That's not in our company's memorandum.
That's not in our company.
Okay.
That's not how our company works.
That's not how our company works.
Do you have any documentary proof that? Okay. Do you have any documentary proof that you tried but check was bounced back? Do you have any deposit slip?
Our account was frozen. We never deposited.
We know that our account was frozen. So why would we?
Your account is frozen. Okay, I got your answer. Okay, please. Your account was frozen. Your account was frozen in the bank system. But you can write a deposit slip, and you are authorized to deposit the slip with check. You didn't do that.
No, Councillor. Why would we do that? The account is in the company's name, so it's the only account for the company.
Okay, it is the only account, right? But in your submission, there was in one place it is written one account, you have one account, other place you have stated that you have accounts, that means many accounts. Are you aware of this?
No. We have only one account. You're misleading the facts.
Okay. If you think that, sorry for that. Okay. And what was your initiative? What was your course of action to deposit the account? Or from your statement, this is very much clear that you didn't deposit the check, right?
Yes, that's correct. That's correct. We didn't deposit it.
The check, right?
Yes.
Did you inform this? Did you inform the same that we are not depositing your check? Did you inform Capital Connection by any means?
It's irrelevant information to you. It's irrelevant information to you.
Okay. Thank you. Okay. Thank you very much. Thank you very much. My cross-examination concluded, Honorable Tribunal.
All right, what is the next now?
Honorable Tribunal, now my turn to give a final speech. Honorable Tribunal, from the statement of the witnesses from fiscal sense, this is very much clear that whatever the disputes or whatever the unwanted circumstances been happened, this is conclusively proved that this was due to the lack of knowledge of managing director, then negligence, and for their inaction. Their accountant don't know the commercial department, how the money come. Their managing director don't know the managerial setup, and we didn't know that. In a good faith, we provided the money in advance, and this is admitted and conclusive that, and they admitted in their submission, and as well as this is perfectly, undisputedly, conclusively admitted that they received the advance. They received the advance, and they are denying this without showing any documentary proof. Whereas we had shown several documentary proofs that we provided them advance, and their negligence or inaction already presented before you. That they are telling that they didn't deposit the check to the bank. They didn't take initiatives. And Honorable Arbitrator, I would like to draw your kind attention to the Money Laundering Prevention Act, Section 14. Subsection 6, money can be deposited in a frozen account. My statement is backed by law. Honorable Arbitrator, in several places in their submission, they provided self-contradictory statement. And Honorable Arbitrator, beautifulness lies in truth. Truth always comes by its own nature. As a part of my statement, in their submission, page number 14, relief sought, they sought relief in favor of us. The tribunal, they wrote that the tribunal to order the respondent need to pay the stipulated amount to the claimant. Page number 14, this is written, Honorable Tribe. I'm humbly seeking your kind attention to this point. Themselves wrote this. Page number 14, clause 1, subclause 4. They sought relief in favor of us. Honorable Arbitrator, in the page number 2 of the agreement, Article 3, subarticle 3.2, Article 3, subarticle 3.2, they admitted the 60% advance. And in the counterclaim, they admitted the 60. They admitted this is a admitted and undisputed fact. In the portion of counter claims, for the sake of argument only, they are telling that they didn't receive any money. But honorable arbitrator, but when the turn of counterclaim comes, they are asking, they are claiming, they are providing counterclaim with the sum of only 40% with interest. They are excluding 60%. If they didn't get money 60% previously, why they are not asking entire money? And this statement is self-contradictory, and this is admitted, conclusive, and undisputed, honorable arbitrator. Honorable arbitrator, as per the existing law, Specific Relief Act 1877, Section 19, provides the power to award compensation. Specific Relief Act Section 19, Specific Relief Act 1877, Section 19 provides the power. As per the Contract Act 1872, Section 73 to 75 provides the power to this arbitral tribunal for the breach of contract by fiscal sense to award compensation. As per the Section 38 of Arbitration Act 2001, this arbitral tribunal can allow award of interest. Sir arbitrator, honorable arbitrator, if you have any question or any clarification, you may ask. I am proceeding further.
Please proceed.
This is my humble submission to this honorable tribunal, that to declare that declare that money back, to provide us our money advance with interest 2,64,800. Honorable arbitrator, the whole scenario, if I give you a summary, they received consideration, not delivered goods properly, contract terminated by the service of default notice by following the due course of law. At this stage, we want our money back with interest and other expenses immediately, honorable sir arbitrator. Honorable arbitrator, in their statement, in their deposition, in their submission, everywhere contradictory statements presented, and their witnesses, they told that when I asked relevant question, they told that this is irrelevant. When I told that when you are suffering from frozen account issues, didn't approach to the Bangladesh Bank Authority, which was the proper forum to resolve the issue, they were telling that this is irrelevant question. Honorable arbitrator, when I was asking that regarding their target market, regarding their managerial setup, they were telling that this is irrelevant question. Honorable arbitrator, the managing it now appears that the managing director was not, or still now he is not aware of the course of business of action, ordinary course of business of action, adequate knowledge. Therefore, because of their negligence, inaction, and arbitrary thinking and activities, all the phenomenon happened here. Honorable arbitrator, I would like to conclude my speech here. If you have any question, you may ask, honorable arbitrator.
Thank you so much. We may please proceed with the next. What is the next?
Thank you so very much, your honorable arbitrator.
Honorable arbitrator, now I'm seeking the permission to complete my argument and summation of this arbitration from respondent side.
Yeah, please proceed.
Much obliged, Honorable Arbitrator. Fiscalsons Limited did not fail to perform the agreement by not fulfilling conditions for obtaining the NOC, facing termination by BIPZA and likely not meeting the agreed upon timeline for the handover of the assets. Fiscalsons signed a memorandum of understanding on 25th September 2020 and applied to BIPZA for NOC. And BIPZA issued NOC on 11 January 2021 with two conditions, namely, the Fiscalsons shall clear all outstanding dues of BIPZA. The required custom formalities must be observed by the seller and purchaser, and customs clearance or NOC should be obtained. But Fiscalsons failed to fulfill the conditions that made the conditional NOC issued by BIPZA invalid. The NOC by BIPZA was the prime conditions for transferring the lease to the claimant, and the claimant had the knowledge that the respondent failed to obtain the NOC. The claimant entered into an agreement with the respondent on 3 September 2021. This makes the contract a contingent agreement where the preconditions were not fulfilled by the respondent, and it makes the agreement between the claimant and the respondent a void agreement. Where the agreement itself a void, there is no question of failing to perform or fulfilling any of the obligations made under the agreement. Therefore, the agreement made on 3 September 2021 is void, and there is no failure of performance of the agreement. The claimant entered into an agreement with the respondent on 3 September 2021 for selling certain assets specified in Schedule B of the agreement, situated on plot NOS 346 to 347 at Sonargaon EPZ, and for establishing prior rights for the transfer of the lease. The claimant agreed on the memorandum of understanding to obtain NOC, but it appears that the NOC was not obtained. The respondent, knowingly the fact of not obtaining the NOC, entered into the agreement. As the agreement is not void itself, then there is no obligation for the respondent to perform any clause mentioned in the agreement. Therefore, the alleged failure of respondent to perform the agreement is not breach of contract. The claimant paid 60% advance of the consideration under the agreement, which is BDT 2 crore 60 lakh 58,240 taka, but it appears to be a frustrated contract because of its contingency. There is no repaying clause in the agreement. The only document of indemnity the claimant is the indemnity signed by the managing director of the respondent in his personal capacity, where he accepts personal liability in certain situation. Therefore, the respondent is not bound to repay the advance money with interest to the claimant, as the indemnity was given by the managing director in his personal capacity. Now, this raises two issues. Firstly, whether managing director can be a party to this arbitration, and secondly, whether the tribunal has the jurisdiction to resolve any disputes between the claimant and the managing director. The managing director cannot be a party to this arbitration, as well as this tribunal has no jurisdiction to adjudicate this matter. But because as per to the arbitration rules, there shall be agreement between the parties, and in this arbitration, the managing director who signed the indemnity is not a party to the said agreement. However, there is a question remains that whether the claimant can file separate arbitration against the managing director. The answer is not. They cannot, as per the arbitration rules. There is no agreement or contract between the claimant and the managing director to resolve such matters before the tribunal. Therefore, the managing director cannot be made a party to this arbitration, nor the tribunal has the jurisdiction to resolve disputes arises between the claimant and the managing director in his personal capacity. The Fiscalsons Limited did not violate good faith and fair dealing of the agreement. In the agreement, the Fiscalsons Limited signed the memorandum of understanding with the claimant. They were prepared to fulfill the agreement, but they failed to fulfill it because they did not get the no objection certificate NOC from BIPZA. BIPZA gave the respondent two conditions to get the NOC. The respondent could not fulfill above conditions. There was a very important reason for this failure. The bank account of fiscal sense was freeze so that they could not do any transaction. The claimant and BEPSA had knowledge that the Custom Bond Commissioner illegally demanded money from the fiscal sense in the year 2018, which dispute remained from 14 September 2018. So for this reason, they could not get the NOC and perform the agreement. The respondent was trying to clear all the required customs formalities. However, the customs authorities was asking illegal means the custom authority did not provide the clearance. Therefore, the respondent failed to receive the NOC from the BEPSA. Thus, the Fiscal Sense Limited did not violate any good faith and fair dealing of the agreement. The counterclaim of Fiscal Sense Limited was legitimate. While the custom bond dispute of the Fiscal Sense Limited was ongoing, BEPSA illegally terminated the lease on 15 July 2022 and thereafter held auction on 20 November 2022. The Fiscal Sense Limited alleged collusion between BEPSA personnel and the claimant and supervision of the agreement. It was contended that these actions of BEPSA and Capital were made in bad faith and Fiscal Sense should be paid the balance of the purchase consideration. Apart from the assets which were sold under the agreement, there were 6,500 pairs of shoes, unspecified construction materials and machineries and equipment, furniture for factory, office and decoration, etc., which in value amounted taka 3,52,77,000. These things were not included in Schedule B of the agreement. So the claimant and BEPSA did not have any right to take those properties belong to the respondent. Accordingly, the respondent raised a counterclaim of this sum together with the balance consideration in the sum of taka 5,02,53,000 with the 15% interest, while denying that the sums claimed by the claimant are payable, as the claimant took some of the properties and materials of the respondent which was not included in Schedule B of the agreement, so that the claimant should pay the sum of the counterclaim of the respondent, which was BDT 5,02,53,000. Therefore, the counterclaim from the side of the respondent was legitimate. A crucial aspect in this evaluation is Fiscal Sense failure to meet specified conditions, leading to capital notice of default and BEPSA's subsequent termination of the lease. However, two significant factors warrant consideration in assessing the priority of BEPSA's actions. Firstly, Fiscal Sense contends that its bank accounts were frozen from December 14, 2018. Owing to an unresolved custom bond dispute, despite this ongoing financial constraint, BEPSA proceeded to terminate the lease and conduct an auction, being well aware of the persistent customs bond dispute. Secondly, the deed of agreement introduces a noteworthy element through its termination clause 8.2. This clause mandates both parties, even in the event of agreement termination, to fulfill certain post-termination obligations encompassing warranties, promise of indemnity, and maintaining confidentiality. The parties are expected to collaborate in settling these responsibilities within 6 months after termination or cancellation. An inconsistency arises in the context as BEPSA was obligated to maintain confidentiality for the following 6 months after the termination. As per the agreement's term, this expectation contrasts with BEPSA's action, which included terminating the lease on July 15, 2022, and publicly announcing an auction of the lease property on November 15, 2022, evidently contradicting the confidentiality requirement. And I would like to conclude by mentioning that the witness of the claimant already admitted that they were indeed aware of the custom bond dispute, and as well as getting the possession handover certificate by BEPSA. We humbly request this honorable tribunal to adjudge and declare that the capital is liable to pay the claimed amount as they are in possession of the asset by BEPSA and they allotted by BEPSA of that assets. That's all from the respondent side's arguments and summation, Honorable Arbitrator. Thank you.
Well, thank you, Honorable Arbitrator, and dear participants from both Sonargaon University and Independent University Bangladesh for this wonderful session. Well, it will take some time to prepare our results. During this period, we will watch a video on introducing BIAC.
Thank you so much.
Sir, we will now watch a video on introducing BIAC, sir.
All right.
Okay, sir. Okay.
Thank you.
Thank you. Well, now I would like to request all dear participants from Sonargaon University and Independent University Bangladesh and our Honorable Arbitrator to open their video for capturing a photograph. Please, participants and Honorable Arbitrator, open your video so that we can capture a photograph. Please, everyone, open your videos, please. I think the photograph has been taken. Please wait some minutes, like around 2 to 3 minutes, so that within time the result will be prepared. Please wait for some minutes.
Can somebody please confirm that they have received the score sheet?
Sir, I am confirming.
You received?
Okay, sir. Just wait a minute, sir. Sir, please, sir.
Okay, sir. All right. So you want me to give some points before that? Would you like me to give out the points before declaring the results?
Sorry, Mr. Arbitrator, are you referring to the participant or?
Sir, no.
I'm asking the organizers, would you like me to give the points?
Got score sheet. Thank you, sir. And I'll like to hand over the floor to you, sir, to declare the result along with the feedbacks.
Okay, so I have to give some points to the participants.
Okay, sir.
So may I?
Yes, sir.
Okay, all right. So results will be declared later by the organizers, which they have received. I have sent to them, and I will give out my point before that. Both the teams have done extremely well. And I'm proud of you, each one of you, and both the teams and their trainers. And I also must thank the BIAC and the organizers to have organized this and to have done it in a wonderful manner. The standards were really very high. And some points which are common points, which will help you in further, not only in this competition, but later in the pursuit of your careers, will be shared now. Please do not take it personal. These are common points. I will not be naming the team, and I will not be naming the person. Now, the opening address has to be quick, fast, concise, brief, and to the point. And also, it should help save time after giving out the contours of their respective cases. We do have the limitations at times in the digital and the virtual environment, and we must be ready to face that. And as you know, that there is a time lag between one's transmission and one's reception. So one has to wait and go slow. Okay. The other point is that while doing your job, you should not get nervous and you should not get agitated and you should not get angry. The best way to get the results out of the witness's mouth is to keep your calm. He will play to your tune. But if you get angry and if you annoy him and if you antagonize him, then you are only wasting your time. Another point, if witness is hesitant, he's not giving you the right answer, it is your fault because you have not framed the question well. The question should get the quick answer because witnesses are habitual and at times they are trained and tutored. They will take you to the tangent. They will continue relating stories and they'll waste your time. So you are the loser. Witness is not the loser. You are the loser. So you have to decide what to do. So you have to move very fast, very quick. Another point. I have seen that when the hypothetical questions were being asked, it was not objected and it was not said that these are hypothetical. But when the real question to the facts were asked, then it was said that it is hypothetical. So if the counsel is giving you example, that becomes hypothetical. And when he's asking you facts of the case, it becomes real facts of the case. So you have to be alive to this. And if you ask a hypothetical question and if a witness is smart, he will continue listening to you. In the end of when you finish, he will say, as and when this thing happens, I'll reply. I'll take a call. So this thing has not happened. So as and when this happens, I will see. So you have to be very, very, privy to this danger. And this is a zone, risk zone, which you are getting into. Another point, if you are modest and you are humble and you are soft, at times the tutoring will not help the witness, because he has been told to say certain things in certain manner. And if you have been told that you have to rephrase, revisit in a different manner, he will come to the point. Now, another point is that do not argue with the witness. It's not done, because witness is the king. More you argue, more you lose. Another point, do not test the knowledge of the witness. Another point, do not show your knowledge to the witness. Both things are not done. Another point, you should have contingencies and options worked out. If he says yes, the next question will be this. If he says no, next question will be this. And if he is neutral, I will resort to this. You have to work out all these in advance. Now, you didn't, suppose you asked a question, you did not take any action. Okay, guys, I think restless. I should wind up. You guys have put in a lot of effort, and I'm very happy to be with you. I will now wind up my points I have conveyed. Now, thank you so much for having me here. Grateful to BIAC, to the sponsors, to organizers, and to each of the participants to have come on this platform and organize this. Thank you so much. Wish you all the best. Now, organizers want me to go or want me to stay?
Sir, you can leave, and thank you, sir. Thanks,
thank you
for your valuable time. Sir, thank you so much. Thank you so much for your feedback.
Grateful to you.
Okay, sir. Thank you so much.
Best of luck.
Well, now it's time to declare the name of the winner. Before declaring, I would like to say that you from Shonaga University and Independent University really played well, but since it's a competition, so we need to declare the name of the winner. So the name of the winner is Independent University Bangladesh, IOB. So congratulations to the team of Independent University Bangladesh, IOB. And thank you also to the team of Shonaga University. You guys did a very good job. Good luck next time. I would like to conclude the session by thanking the chairperson of today's session and team members of Shonaga University and Independent University, along with their faculty members, who worked hard to train up and prepare the students for the contest. Congratulations again, once again, Independent University Bangladesh, and better luck for semi-finals. Congratulations.
Thank you so much, ma'am. Thank you.
Okay, everyone. Thank you to both teams for your participation. Thank you.
Thank you, BIAC, for organizing this event, and congratulations to the winner party.
Okay, thank you to you. Thank you to the team of Shonaga University also for their participation and for their efforts. Okay. Okay, better luck next time. So goodbye.
Thank you.
Thank you.